After 25 years of service,
Yes,
my service has
then
been,
you have to return all whatever service benefits you have earned.
my lord, then,
Have you not denied opportunity to similarly situated persons? Political appointment.
my lord,
Political appointment.
my lord,
Your
petitioner,
appointment is at the behest of Deputy Minister, Water Resources.
my lord,
Correct?
my
You
lord.
are not subjected to selection process.
Fourth class employee has been terminated, my lord,
Sir,
without
poor,
any
you can't say poor class. You have the influence of Deputy Minister, Water
my lord,
Resources.
my lord,
You had a resource, good resource.
On
What,
my,
that is not
I'll
there?
seek instructions
Why
that
you have not taken any action against the civil surgeon?
that my lord is absolutely
Your
correct.
civil surgeon is a
My lord,
subordinate and a servant to the minister.
there is some delay in filing of this LPA against the order of learned single judge, my lord. For the condolation of delay, we have filed an IA in this LPA, my lord, that may be considered, my lord.
Political appointment.
My lord,
Political appointment.
my lord,
Your
petitioner,
appointment is at the behest of Deputy Minister, Water Resources.
my lord,
Correct?
My
You
lord.
are not subjected to selection process.
my
That
lord.
means Article 14-16 is not complied.
My lord, but my case is, my lord, after 25 years of service,
Yes,
my service has
then
been,
you have to return all whatever service benefits you have earned.
my lord, then,
Have you not denied opportunity to similarly situated persons?
my lord, appointment has been done by competent authority on the
Sir,
recommendation of,
were you subjected to selection process? Inviting application from the eligible candidates. Where is the advertisement? Where is the selection process?
my lord,
Just because
my lord,
the then deputy minister for water resources asked the civil surgeon to appoint a petitioner to the post, you are appointed.
my lord, I can show,
Yes, who is appearing for state?
my lord, I am appearing on behalf of
What
state.
action you have taken against the civil surgeon?
My lord, that is not there. On
What,
my,
that is not
I'll
there?
seek instructions
Why
that
you have not taken any action against the civil surgeon?
that my lord is absolutely
Your
correct.
civil surgeon is a
My lord,
subordinate and a servant
my-
to the minister.
My lord, the instructions which I have received is that there was a complaint which was against this petitioner and other similarly situated against the civil
Please
surgeon.
answer to the court. Please answer to the court
Probably,
question.
my lord, there might be an action. I'll seek instructions
Where is
because
the action taken?
there was a complaint with the Lokayukta. On direction of the Lokayukta, this whole action was taken by
All right, what is the action taken against
my
civil
lord, I'll
surgeon?
seek instruction and I'll file on that. Really. That what was the action taken on that?
You don't know
Civil
case, we will reject.
my lord, my humble prayer is, my lord, after 25 years of service, one fourth class employee has been terminated, my lord,
Sir,
without
poor,
any
you can't say poor class. You have the influence of Deputy Minister, Water
My lord,
Resources.
my lord,
You had a resource, good resource in getting appointment.
my lord, what I am requesting, my lord, it's true, my lord, that I had approached with an application that my husband is 60% handicapped. I had no means.
Sir, where
of-
is the advertisement?
My lord,
So
my lord,
clear case of violation of Article 14 and 16.
my lord, but no violation has been done on the part of this very petitioner, my lord.
All right.
And he is suffering
You were
after
the
25 years
beneficiary.
of service, my lord.
In fact, you have to shell down whatever the monetary benefits you gain. Shall we order for recovery?
No, my lord.
Yes, take down. In the instant appeal, appellant has questioned the validity of the order of the learned single judge dated 21/10/2019, passed in CWJC 17179 of 2019. Please stop. The appellant was appointed to the post of lady ward attendant by order dated 29/7/1995 in the pay scale of rupees 775-1125 by the civil surgeon by the then civil surgeon dash cum medical officer on the recommendation of the then deputy minister Water Resources Department, and the the then Honorable Chief Minister of Bihar. The respondents noticed illegalities in the appointment of appellant, and proceeded to terminate the services of the appellant on 3/7/2019. 28/6/2019, and it was communicated to the appellant on 3/7/2019. Who is feeling aggrieved and dissatisfied with the order of termination, appellant preferred CWJC 17179 of 2019. Next paragraph. On 21/10/2019, that single judge dismissed the petition. Thus, the petitioner has preferred the present appeal. Learned counsel for the appellant vehemently submitted that, having regard to the length of service rendered by the appellant, termination after lapse of 2.5 decades is not proper. Raking up order of appointment dated 29/7/1995 in the year 2019 is unfair. The learned single judge has not appreciated the aforesaid issues while rejecting the petition. Therefore, the appellant has presented this appeal to examine the raking up of belatedly in respect of appointment issued on 29/7/1995. Heard the learned counsel for the appellant. Undisputed facts are that appellant was appointed to the post of lady ward attendant on 29/7/1995 at the behest of politicians, namely the then Honorable Deputy Minister, Water Resources Department, and the Honorable Chief Minister of Bihar, which compelled the civil surgeon -- medical officer to appoint appellant on 29/7/1995 to the post of lady ward attendant. Such appointment to a public post is without resorting to Article 14 and 16 read with relevant rules in respect of filling up of lady ward attendant in the health department. Full stop. The learned single judge has taken note of in para 5 and 6 of the order relating to violation of Article 14 and 16, and so also considering KP Tiwari decision, Union of India and other sources, KP Tiwari reported in within bracket 2003 9 SCC. The appellant's contention that belatedly raking up the issue of illegal appointment order dated 29/7/1995 in the year 2019 is not appropriate, cannot be appreciated for the reasons that Apex Court in the case of Dr. Rajkumar versus Gulbarga University held that illegality is an illegality which cannot be cured. In that decision, there was a delay of 10 years in interfering with the order of appointment to the post of lecturer, to the post of assistant professor. That apart, Apex Court in the case of Renu versus so and so High Court elaborately discussed in respect of public employment that invariably Article 14 and 16 is required to be invoked for the purpose of any public post. In the light of the aforesaid decision of the Apex Court, the contention of the appellant that appellant has worked for 25 years, therefore illegal appointment issued on 29/7/1995 cannot be interfered in the year 2019 while terminating the services of the appellant cannot be appreciated. Accordingly, the present appeal stands rejected while affirming the order of the Learned Single Judge dated 21/10/2019 passed in CWJC 17179 of 2019.